Back in August, a federal public defender in Washington County filed a lawsuit against the sheriff's office on behalf of multiple defendants who argued that holding them in jail without public defenders available deprives them of their Sixth Amendment right. This led to federal Judge McShane's original 10-day ruling. That 10-day release ruling only applied to Washington County, but was later extended to the whole state of Oregon and shortened to 7 days.
It's frustrating because the 7 days is a really short period of time. Of course, anyone who's in custody needs to have a lawyer, and we all agree with that. But my concern becomes when it becomes a public safety issue and we can't find lawyers. And that's the problem that we have in Jackson County, is we have more cases than we have lawyers who can handle them.
Because of public safety concerns, the Oregon Department of Justice requested that the Ninth Circuit Court of Appeals hear this case to determine if it should go forward, which is why the ruling was delayed until November 23rd. But as of November 15th, it's officially blocked. Prior to Judge McShane's decision, there was no federal time limit on how long defendants could be held in custody without representation. In Oregon, you get a trial within 60 days of being charged, but some people were being held in jail that full 60 days.
That was basically 2 full months people were being held, and then they get out, and of course, at being gone for 2 months, being held in jail, your job's not there, your rent's not paid, all those kinds of things. Aside from a public safety perspective, there's always this concern that 7 days isn't long enough. However, when you consider it, we are a nation of a rule of laws. We have a constitution for a reason, and so for public safety purposes to say, oh, we need to suspend the Constitution, I think would be a gross deviation from the norm of what our society is built on.
With all of Oregon's law schools being in the north, another main concern with this decision, especially here in Southern Oregon, is the fact that there is a public defender shortage. So how are attorneys going to be able to respond appropriately if this new ruling passes?
We'll take cases at the beginning of the month. We'll be taking them, basically having to review the list. We keep space open for the more serious, violent charges that might be lodged. If someone was charged with murder were lodged, yeah, they would get an attorney. That's just how it would work. We also set aside for more serious crimes, sex crimes, robberies, armed robberies. We have numbers set aside where we appoint those in the middle of the month and the end of the month to make sure we have the space available to take those when they come up.
While public defenders do have procedures like this in place, prosecutors are still worried because the possibility that violent offenders get released still exists.
We honestly could have a very serious offender who, if we can't get them a lawyer in 7 days from their initial appearance, is going to get released. We have, serious cases, child abuse cases. We could have a homicide, a murder, a manslaughter, domestic violence cases. So we have a lot of different types of cases where the victim does feel a little bit more secure knowing that the person is in custody.